Good afternoon, everybody. My name is Chris Justice. I'm an employment lawyer with Samfiru Tumarkin. And as always, I am here today to hopefully answer as many questions as I can, all things employment law related. So if you've got a question about a contract, maybe you've been let go, you're wondering about some severance, or perhaps you're just going through some issues in the course of your working relationship with your employer, again, I'm here to hopefully answer all the questions. So do get your questions in. And once I finish off with a little bit of information off the top, as I usually do, I'll get into the questions. This time around, in terms of what I wanted to start off talking about, had to do with records of employment, ROEs, something that comes up a lot in my practice. A lot of times clients or prospective clients will ask certain questions about ROEs. So I figured it'd be good to give a little bit of a primer on those ROEs, things to hopefully understand a bit better and just get a sense of what the entitlement or what options people have when it comes to issues with ROEs. So just to start though, record of employment being a formal document that contains your employment information. So it'll highlight things, for example, including how long you've been at the company. It'll highlight things like what your insurable hours or earnings are for purposes of applying for EI. And it'll also specify usually the reason for why you're no longer working at the company, whether it be a resignation, could be something given to you if you're being placed on a temporary layoff as well. But the document itself, the ROE, is very key and essential for those applying for EI benefits, which I mentioned, because it's going to help Service Canada determine, number one, if you're qualified for EI benefits, number two, how long you'll get those benefits, and it can also help in protecting against possible fraudulent claims. Now, when it comes to the issuance of an ROE, ROEs being given by your employer, when do they have to do it? When are they required to be issued? And normally the ROE is going to be issued when there's been an interruption in your earnings. So again, it could mean a termination. So there won't be any further earnings past that point. It could be you being placed on a leave of absence or going on a leave of absence yourself. That could be another interruption, or as I say, maybe a layoff. But typically when the employment ends, you're going to get the ROE. But as I say, there's instances where employment doesn't necessarily end, where you're also issued an ROE. So for example, if your earnings are $100,000 a year and they drop to something below 60, so below 60% of your earnings, for example, due to an illness, an injury, maybe a maternity leave, these are going to be other instances where ROEs need to be issued. And they need to be issued even if the employee, the person who's receiving the ROE, has no intention of actually applying to EI. It's still a standalone requirement and obligation that employers have to departing employees or employees going off on leave. As far as the timing of when an ROE needs to be issued, a lot of people ask me that question as well. And the deadline as far as when the ROE needs to be issued will depend on whether or not the ROE is given to you in sort of a hard copy paper format, or whether the ROE is provided on electronic basis. So for paper ROEs, for those done in writing, sort of like a hand-delivered ROE, the employer has to issue it within 5 calendar days of either when your earnings are stopping. So if you're being let go January 1st, 5 calendar days within that point, or whenever the employer becomes aware of the interruption in your earnings. So there could be, I suppose, a circumstance where the employer is not aware as to the exact date the earnings stopped, and maybe through an inadvertent error or mistake, or sort of not knowing what the timing is for that, a record of employment in case of a paper record of employment could be issued possibly a bit later than 5 calendar days. So that's with respect to paper ROEs. Now, when it comes to electronic ROEs, something that's probably more common nowadays, the timing of when that needs to be given will depend on the employer's pay period. So for instance, if you are on a weekly or a biweekly or a semi-monthly pay period, the ROE has to be issued within 5 calendar days of that pay period ending. But where you're an employee who gets paid on a monthly basis or every 4 weeks, then the ROE needs to be issued either within 5 calendar days of that pay period ending or within 15 calendar days from the day the interruption of the earnings started. So whichever would come first. And again, it's important for employers to be issuing ROEs within the deadlines, because if they don't and they go past whatever the deadline is, that's going to, or at least can, result in penalties to that employer. So that could include things like fines. I think the legislation speaks to upwards of $2,000 being fined, as well as possible imprisonment or both. So the penalties, the repercussions, the consequences for not issuing ROEs on a timely basis can definitely negatively impact companies to varying degrees. And you should, when you get a record of employment as well, you should take notice of the reason for why the record of employment was issued. I mentioned off the top, one of the key things the record of employment will speak to is the basis or the circumstances which led to the end of your employment, or maybe the stopping of your employment on a temporary basis. So there's usually different letters that are associated when it comes to this kind of stuff. So if you have code A in your ROE, that usually means a shortage of work. If you've got code E, that means that it's typically a resignation, someone has quit. And code M, M as in mother, would be for dismissal. So those would probably be the most common, A, E, and M. With M, when it says dismissal, though, sometimes it's not clear on the record of employment that the dismissal or the termination was done on a without cause basis, or whether the termination was done on a for cause or a just cause basis. Sometimes, because the record of employment isn't that precise, there's going to need to be a conversation between the employee and Service Canada to maybe get a bit better of an understanding in terms of what the dismissal was for. Because until Service Canada can confirm that the dismissal was without cause, they're going to potentially withhold benefits until that gets verified. If you're somebody who's been let go for cause, or at least the allegation has been put forward as cause, that could affect your ability to collect EI in the same way that resigning would affect your ability. But that's why I think it's all the more important that if there is some ambiguity or uncertainty around the reasoning for the dismissal, you want to at least let Service Canada know from your end of things, and then they'll typically go to the employer and sort of ask for their side of the story before deciding whether or not to approve the benefits. So just some key takeaways from this would be ROEs are essential if you want to collect EI. Employers have to promptly issue ROEs once there's been an interruption in earnings. And if not, they face penalties for the late filing of ROEs, or even if they file the ROE on time, but they do it inaccurately, that could also lead to punishment. And people out there may be wondering when they can get their ROE, or if they've got their ROE, you want to, just because a lot of times it's done electronically, you want to go on your Service Canada account, which should be accessible online. And usually through that, you can view and download your ROE if it hasn't been given to you in sort of that hard paper format. But having said that, I'll get into some of the questions. And if I've got some time at the end, I was going to touch a little bit on doctor's notes and sort of the role that they play in the workplace. But I'll start with the first question from Facebook. Ermail has said, can my medical records be shared to opposing counsel and mediator by my lawyer without my consent? So first of all, if you have a lawyer, you're the lawyer's client, you would be giving instructions to your lawyer. So the lawyer should be acting in accordance with those instructions. That would be number one. But as far as how the law treats medical records and whether or not the law would say medical records ought to be shared, it's going to depend on the circumstances of your case. So if your case is one where there are a lot of medical issues at play, maybe there's a dispute between you and your employer about something related to medical issues, then I could see it being more likely that records will be relevant in your case and that you'd have to provide them. It's not to say that you have to provide literally every record, and there might be some things in your records that are maybe more sensitive or privileged, and those things can oftentimes be redacted. But it'll really come down to the individual case. So in some cases, employers ask for a bunch of medical records when there simply is no reason or basis to do so, and it just becomes a fishing expedition. But then in other cases where someone's health or medical status is called into question or is an area of dispute in the case, medical records would generally be, as I say, more relevant. And you may be wanting to provide those medical records because if you have medical records that support maybe your inability to work, or maybe they support your inability to work your full job, they could also support your inability to look for new employment once you have been let go from a certain position. Then in often cases, those medical records can actually be to your benefit and can give you more leverage as the employee. But, again, you want to be careful that you're not just disclosing medical records for the sake of it, especially if there's particularly private or confidential things in those records. Got another question in from Art, who's asking whether or not an employer can let you go for speaking to a lawyer about a problem at work. So the short answer to that is yes. An employer can let you go essentially for any reason. May not be the best reason just because you're speaking to a lawyer, but they can still let you go. And the question, if they do that, will be, what severance do they owe you? Because certainly talking to a lawyer is not going to be grounds to let somebody go for cause. It could arguably be some bad faith there. I mean, if someone is speaking to a lawyer to get some advice that's reasonable to get, and the employer sort of punishes them in some respect, lets them go, maybe disciplines them simply for getting legal advice, that could arguably be deemed bad faith and could actually expose the employer to not only having to pay full severance, but also additional damages for that bad faith argument or that bad faith angle that you might want to take. But as far as just being let go, they can essentially do so for any reason as long as it's not outright discrimination. So unless you are being let go for some reason that's protected under human rights legislation, then even if it's, like I say, a bad reason to let you go or not the best reason, or maybe it doesn't make sense, maybe they just don't like you, typically courts are going to allow that because it's their business. They're free to engage in that sense. But I think the problem comes when they let you go and then they shortchange you on your way out, or they don't give you the severance that you're owed, which if that's the case, then you definitely want to get in touch with us. I've got another question in from Sir on YouTube, or sorry, on Reddit, who's asking, are employers forced to hire the most qualified person? If I can prove I'm more qualified, do I have a case for being hired? And it would be tough. Employers do not have to hire the most qualified person. Employers are free to hire whomever they want. Again, as long as it's not in somehow related to a human rights concern. So I suppose if the evidence showed that there were maybe two equally qualified people, or it doesn't even have to be qualifications necessarily, but if someone is denied a position on the basis of the color of their skin or their gender or sexual orientation, for example, then yes, that is going to violate the human rights legislation. But oftentimes employers don't necessarily hire the best person, which again may not be good for business, but it's not something that would be typically seen as illegal by the courts. So you'd have to really show that there was some, extreme discrimination, which, to be fair, can oftentimes be difficult to prove. But if possible, then there might be a case there to be had along the bad faith line of reasoning. Another question in from Sandy on YouTube, who's asking whether or not you can ask your employer for a better severance offer after you've been let go. And absolutely, that's one of the main things that we do here at the firm, is negotiate better severance offers with the employer. So people should know that whenever they're let go and they're offered a severance package, even if that severance package looks relatively good, fair, odds are it's not. Odds are most packages people are given from the outset are pennies on the dollar. And it absolutely, in those cases, makes sense to negotiate with your employer for a better severance package. You can do that potentially on your own, although you may not have as much leverage. Or you can get a lawyer involved, someone at our firm, for example, someone experienced who can sort of explain to you what a severance offer looks like, what a reasonable severance offer looks like, maybe give you an idea of how far short the offer you've been given falls from what your potential is. And but yeah, absolutely, if you're someone in that situation, you definitely want to give us a call, if anything, just to get a sense of what your rights and options are. And as I say, we have a lot of success over here at the firm when it comes to negotiating better severance packages. Got another question in from Fred on YouTube, who's asking, if you work after being laid off and you lose your job before termination, is that money from employment deducted from any settlement with your first employer? Okay, so you've worked, you've been laid off, and then you're saying you lose your job before termination. So I assume then what you're saying is your employer, the first one, did not terminate you, but maybe placed you on a temporary layoff with the expectation of calling you back. And then prior to them reaching out and maybe advising or confirming that you've been let go, you may have got money from another job. So if that's true, if I have the situation correct, then yes, there is the potential that the money you make in another job after maybe being let go or being laid off could be deducted or from any settlement or be credited towards the first employer. This would be called mitigation. So anytime someone mitigates their damages by finding a new job after they've been let go from the first, as much as that's good for your life in general to get a new job, it may actually get the first employer a little bit off the hook when it comes to their potential liability. It's just that those who find jobs shortly after being let go are typically not going to be looking at as much severance as those who are let go and then have to go several months, if not years, without a job, despite, maybe giving some efforts to look for work. But thank you for your question. I've got another one in from Sir on YouTube, who's asking or saying that their employer let them go for financial limitations. The employer told other stakeholders and other employers that they left. Can there be a claim for damages? And if so, how much? So if the employer let you go for financial limitations, then to me, that would seem as though you've been terminated. They're telling stakeholders that you left. That statement, though, is a bit ambiguous because it doesn't really specify the circumstances under which you left. You could interpret that as meaning you quit. You could interpret that as meaning you're no longer at the company, whether it's quitting or being let go. So I think it would depend on whether you can show that your employer told all these stakeholders that you specifically quit your job as opposed to you being let go. But that said, the claim for damages, even in that case, might be hard to argue. I would look at the ROE they've given you. So if it says you've been let go versus that you've quit, then it definitely would seem to me that you have a case for severance. But as far as an additional claim for damages because they told the stakeholders that you left, I think without some more information or detail, it'd be hard to prove or give you some guidance on how much bad faith there is there. But if anything, if you want to give us a call, I'm sure we can chat about it further and at least, as I said before, give you an idea of what your options and entitlements are in that case. I've got another question in from Soggy on YouTube, who's saying, if an employer asks you to relocate to fill another role at another location, and then you do relocate and they decide to keep you in the same position you left, what can you do? So that could be a possible breach of contract if there was an agreement perhaps signed or maybe not, maybe it was a verbal discussion, but an agreement nonetheless that said you will move to this location and you will do this specific role, and you get to that location and you're not given that specific role, then there's clearly a breakdown in the understanding or the agreement that you had. And you may be able to treat that breach of contract or agreement as essentially a termination. Whether you actually decide to leave the company and go after them for your severance, or whether maybe you decide to use that as a possible leverage point to get them to simply keep you in the job that you agreed you would go to, that could be discussed, I think, in more detail with an employment lawyer. But from just looking at your comment, it does seem like there was an understanding and then they breached it. So I'd say give us a call before you have any substantial conversations with your employer about this, because as I say, you may have at least a couple of options, whether it's to try to look to leave and get severance, or possibly use the argument that I was mentioning as leverage to ultimately get what you want and keep your job. But thank you for your question. I've got another one in on YouTube from Amateur who's saying that they were told by their employer that when they got a doctor's note that it said they could return to work, it wouldn't be a direct return to work. Their lawyer would have to review the note to see whatever treatment I had received was sufficient. And the question is, can they refuse to let me return or lay me off? So this does come up quite a bit. I guess it would depend on what the doctor's note says, depend on how much detail is given in the doctor's note. Usually when it comes to doctor's notes, which actually was going to be something I was going to touch on at the outset of today's show, there only needs to typically be a few pieces of information in the doctor's note to have you come back to work. So the first thing would typically be a confirmation of what any limitations or restrictions you have, along with maybe some symptoms. So not to say your doctor needs to disclose a diagnosis, but if the note sort of lays out symptoms that you're suffering from and also lays out how those symptoms are or would affect your ability to do your job, then that's usually sufficient on its own. And then the other thing that usually needs to be included in a doctor's note is a prognosis. So it's good enough to say, these are my restrictions, these are how my restrictions relate to the workplace, and therefore this is the job or the part of the job I can do going back to work. But then you also want to have a prognosis that will speak to the likelihood of recovery, maybe that will speak to how long these restrictions or limitations need to be put in place. So as long as it has this, at least these key pieces of information, and there's no other reason to doubt the legitimacy of the doctor's note, there's no other notes maybe that were given prior that say something completely different, then it's going to be very hard for the company's lawyer to push back on it. Sometimes they'll try to have you see their own doctor, which is not reasonable unless there's some clear reason that the note you gave was illegitimate or inaccurate or unreliable. Other times, the lawyer for the company may not have you assessed by an independent doctor, but the lawyer may be still asking for more information. And it depends also on what information they're asking for. So sometimes you'll give a note that sets out your limitations and your prognosis, and then the company will come back and say, well, that was good, but we want more information. We want A, B, C, D, E, F, G. And depending on what those are, that can be going too far. A lot of times employers like to get everything they can from a medical perspective because they're just hoping and praying that they'll find something that can justify maybe in pushing back on your offer to return. But in a lot of cases, that those questions are often unwarranted, and they may just be asked to you to frustrate the whole process in general, which can then lead to potential damages against the company for failing to accommodate, for failing to have you return to work, for asking for unreasonable or unnecessary information when everything within reason has been given already. So there tends to, in a lot of cases, be that battle where the notes you give aren't sufficient from the company's perspective, but you've given them everything that you need to. And in those cases, I typically suggest people give me a shout or give us a call at the firm so we can at least go over it and get a better understanding of how much bad faith there may be or whether the employer's requests are reasonable at all. But thank you for your question. I've got another one in from Patience on YouTube who's asking whether or not you can expect any common law severance when you've signed away common law severance entitlements in your employment offer when you started the job. So I would say that even though in a lot of cases people sign contracts, and even though in a lot of those cases the contracts have some sentence or two or three in there that says you do not get your common law severance if we let you go, the vast majority of those contracts that say that are still not worded in the way that they need to be. And so I would never assume that just because you've signed something that you may think takes away your common law severance, that it actually has that effect. Because as I say, most of the time it doesn't, but that usually requires an experienced employment lawyer to look at your contract, look at the language, the words that are used in that contract, and sort of look to poke holes in it in terms of what's being stated in there. And so patients, I would at least advise you to contact our firm just so we can have a look at the contract and then give you a better sense of whether or not this company has any leg to stand on. Because it is possible, I know I say it's rare, but it is possible that you can sign a contract that essentially gives up all your common law severance entitlements. And that would be a huge loss because, you're often talking tens of thousands of dollars more, if not even greater. But it's just so rare that I see those contracts that are ironclad. And so it's all the more reason to have you reach out to us so we can assess whether or not you're entitled to your full common law or if you're just limited to the bare minimums under the employment standards legislation. I've got a follow-up note from Sir on YouTube who has said that the employer let them go for financial limitations. So sorry, sir. This was a repeat of your previous question. So I'll just refer you back to the answer I gave earlier. But if you need more information, definitely give us a shout, and we can get into the nitty gritty in terms of what was said and give you a better sense of what your claim for damages are. I've got a follow up from Soggy on YouTube who is just saying or asking, if I decide I don't want to stay because of this, can I go after them for expenses incurred? And yes, that's a potential. So if you had relocated on the promise or the understanding of a certain set of terms, and so you committed in moving to that spot on the reliance of those statements or of those promises that were given to you, and you incurred costs in having to relocate, or it could be anything, doesn't have to just be relocation, but if you've basically incurred costs in reliance on what was told to you and now it's to your detriment, then yes, there is the possibility to not only go after the company for damages or severance or bad faith, like I mentioned before, but also expenses that are related to that understanding. So yeah, you definitely don't want to leave any stone unturned. And I like to start off personally on the more aggressive side, because I know, whatever you go to your employer with first in terms of a proposal, oftentimes they're going to reject it and then look to possibly negotiate from there. So you want to try to include everything you can, at least to start with. I've got a follow-up from Sir. So let go limitations financially, code K was given, and they told, again, the stakeholders and other employees that they left. Code K, that is a bit of an ambiguous code. I believe it refers to other, meaning maybe a circumstance where you've left the company, but it's not due to a shortage of work or due to resignation or whatnot. Although when you say financial limitations, to me, that seems like you're being let go due to a shortage of work, or something obviously related financially. So it seems to me like code M or code A would have been more accurate in your case. Code K, like I say, it's a bit unclear, but I guess a question for you would be, did your employer give you any severance? So you've said they let you go. So did they offer you anything of a package? Do they send you anything in writing that says, we're letting you go, this is what we're going to do, we're going to process the ROE, et cetera, et cetera? So until I have that information, until I know, a little bit more information on your end, it'll be hard for me to give you an assessment. I'd still suggest you give us a shout, at least to book a consultation, just to go into it more depth. Because it does seem like there's something kind of off about this case, and there does seem the potential for damages. But before I get into too much, I think it'd be better to have a more fulsome conversation. But that's going to do it for my time, though, today, everyone. So I've answered all the questions. Thank you for those that did get their questions in. As many of you know, we do this all the time. We've got another session just below there you see with Karen tomorrow at 1 o'clock Mountain Time. So for those that may have questions that I didn't get to, please tune in tomorrow. And I'm sure Karen will do her best to answer as many questions as possible. But again, thanks for everyone. Thanks for your time. And I will be back soon enough. But until then, do take care. Bye for now.